The Supreme Court just dropped a 6-3 emergency ruling that's going to affect millions of Americans in ways most people don't even realize yet. This isn't just a legal tweak, it is a fundamental demolition of how federal power has been checked for the last 20 years, and the implications are already rippling through courtrooms nationwide. Before we dive into what just happened, hit subscribe so you never miss critical Supreme Court decisions that directly impact your life. Here's what actually went down in the early hours this morning. The Supreme Court issued a 6-3 emergency decision that completely transforms the national injunction power, a tool that has been the primary weapon for activists on both the left and the right for decades. A single federal judge in a single district, say in the middle of Texas or the coast of California, could issue a ruling that froze a law across all 50 states. The majority opinion makes it crystal clear: those days are over. Federal judges can no longer grant what's called universal injunctive relief, where a single court order prevents a law from being enforced against anyone anywhere in the country, even people who aren't part of the lawsuit. This might sound like technical legal procedure, but consider the scale of this practice. Over the last decade alone, there have been more than 60 nationwide injunctions issued by single federal judges. In the past 5 years, federal courts have issued 83 universal injunctions that protected millions of people from laws they never personally challenged in court. This effectively allowed one person in a black robe to override the will of the entire United States Congress or 50 state legislatures. What the Supreme Court just did was eliminate that protection for everyone except the specific individuals who actually filed the lawsuit, and slam the brakes on a practice that's been the foundation of federal litigation strategy for 2 decades. And the timing? It couldn't be more critical. We currently have 47 active cases across federal courts where states or advocacy groups are seeking exactly these kinds of blanket injunctions. From immigration to environmental rules, from healthcare access to voting rights, the legal shield used by millions of people just vanished. But here's what nobody's talking about yet, and it's the part that's going to create the most chaos in the coming weeks. The decision applies retroactively to existing injunctions, meaning legal protections that millions of Americans have been relying on could disappear within days. The constitutional reasoning behind this decision goes way deeper than most legal analysts expected, and it's actually the most fascinating part of this entire ruling. Justice Gorsuch's majority opinion includes a 47-page historical analysis examining federal court practices from 1789 through the end of the 19th century. He identifies 23 separate cases where early American courts explicitly rejected requests for relief beyond the named plaintiffs, even in cases involving obvious constitutional violations affecting thousands of people. He references 12 separate founding-era cases where judges explicitly rejected requests for broader relief, even when the plaintiffs argued it would be more efficient. What makes this historical analysis particularly powerful is the evidence showing that founding-era judges viewed their role as resolving specific disputes between specific parties, not issuing broad policy directives that functioned like legislative acts. This matters because it suggests the entire practice of nationwide injunctions has zero constitutional foundation. According to the majority, it's a modern invention created out of thin air by activist courts in the 1960s. Justice Thomas went even further in his 31-page concurrence, pointing directly to Article 3 of the Constitution and arguing that federal judicial power is inherently limited to cases and controversies. He points out that this phrase appears 6 times in the Constitution, and in every instance, the historical record shows it meant concrete disputes between identified parties with direct personal stakes. By definition, that means specific disputes between actual parties, not abstract policy disagreements affecting 330 million people who aren't even in the room. The 3 dissenting justices tried to counter by citing the civil rights era, arguing that without these broad powers, desegregation would have been impossible. They pointed to precedents from the 1950s and 60s where broad injunctions helped desegregate schools and protect voting rights, but the majority's response was chilling for legal scholars. They essentially said those cases achieved good results through constitutionally questionable means, and that getting the procedure right matters more than expedient outcomes. They suggested those procedural points in the 1960s were simply wrongly decided. What makes this particularly explosive is the immediate effect on the 34 states currently operating under injunctions that the majority just declared illegitimate. Within 3 hours of this ruling being published, the legal landscape began to fracture in real time. Attorneys general from 18 different states filed emergency motions in their pending federal cases, with 9 states citing the decision to request immediate enforcement of previously blocked laws, while 9 others scrambled to protect their residents from those same laws. Texas moved first, filing motions in 7 separate cases challenging everything from federal immigration policy to healthcare regulations to election law. Within 2 hours, California filed counter-motions in 5 cases, arguing that even under the new framework, preliminary injunctions should protect entire classes of affected individuals, not just named plaintiffs. Florida referenced the decision in 4 different lawsuits involving election procedures, social media regulations, and environmental standards that have been frozen by injunctions for the past 18 months. Arizona invoked it in a border security dispute that's been tied up in the Ninth Circuit for 8 months. The speed of these responses tells you everything you need to know about how significant legal strategists view this shift. What's even more interesting is what's happening inside the federal government itself. According to sources familiar with the matter, the Department of Justice held an emergency strategy session at 6:30 a.m. this morning involving senior attorneys from 11 different divisions. The White House counsel's office is reportedly advising federal agencies to prepare for state laws they thought were blocked to suddenly start being enforced again. We're talking about laws regarding health care, voting, and firearms that were frozen by a judge's pen. They could be live as soon as next Monday in some jurisdictions, potentially affecting millions of people. Republican governors are already announcing plans to move forward with enforcement. Meanwhile, Democratic state attorneys general are scrambling to figure out how to protect their residents from what they view as harmful policies in neighboring states. But here's the question everyone should be asking. If constitutional protections can evaporate overnight based purely on who happened to file the original lawsuit, are we really talking about rights or just temporary privileges that disappear when court procedures change? If your rights depend on which state you're standing in when you assert them, do you really have constitutional rights at all, or just geographic privileges? If a federal law is unconstitutional in New York because a judge there blocked it for local plaintiffs, but is perfectly legal and enforceable in Ohio, the very idea of a United States begins to dissolve. This ruling creates a patchwork of legality where the same action could be a crime in one zip code and a protected right in another. The answer to that question determines what happens next with the massive shift in legal strategy that's already underway. This ruling completely rewrites the economics of federal civil rights litigation, and the numbers are staggering. For the past 25 years, advocacy groups have used a tactic called forum shopping. They find a district known to have a sympathetic judge and file there to get a nationwide win. The data on this is wild. Between 2017 and 2021, 78% of nationwide injunctions against federal policies were issued by judges in just 5 specific districts that represent less than 4% of the U.S. population. Between 2015 and 2024, just 47 lawsuits filed by civil rights organizations resulted in injunctions that protected an estimated 68 million Americans from various state laws those organizations considered unconstitutional. Now that the Supreme Court has killed this strategy, the cost of fighting for your rights is about to explode. Organizations seeking broad impact will need to file separate lawsuits in every single federal district where the challenged law applies. A case that previously required one filing in one friendly district might now require 20 or 30 separate filings across different circuits. A state law that applies statewide might require 15 to 20 separate lawsuits, each needing its own legal team, its own discovery process, its own trial, and its own appeal. Major law firms are already sending memos to clients explaining that civil rights litigation and environmental challenges could now cost 5 to 10 times more than they did last month. Major public interest law firms are already circulating internal memos explaining that cases that previously cost $200,000 to litigate might now cost $3 to $4 million to achieve the same protective scope. What makes this particularly concerning is the impact on smaller organizations and individual plaintiffs. The ACLU released a statement this afternoon noting that they handle approximately 140 active federal cases at any given time, and under the new framework, that number would need to increase to somewhere between 800 and 1,200 cases to provide the same level of protection to the same number of people. The National Immigration Law Center pointed out that their entire annual litigation budget equals what it would now cost to fully litigate just 3 of their current cases under the new multi-district requirement. But what almost nobody has noticed yet is how this affects the specific category of cases where the consequences are most immediate and most personal, and where the stakes are literally life and death. Let's talk about what this means for actual people seeking medical care right now, because healthcare represents the most immediate pressure point. There are currently 17 active injunctions protecting access to various medical procedures, medications, and treatments that could be narrowed to cover only the specific plaintiffs who filed the original lawsuits. Abortion medication is the obvious flashpoint, with 4 separate nationwide injunctions currently preventing states from enforcing restrictions on mifepristone and misoprostol. Under the new framework, those injunctions might only protect the specific women and healthcare providers named in each lawsuit, meaning enforcement could resume against everyone else, potentially affecting access for millions of women in 19 states within the next 30 to 60 days, depending on how quickly lower courts issue clarifying orders. Gender-affirming care faces similar uncertainty, with injunctions in 6 states currently preventing enforcement of laws restricting hormone treatments and surgical procedures for minors. If those injunctions get limited to named plaintiffs, state officials could immediately begin enforcing restrictions on families not specifically protected by court orders, creating situations where your child's access to medical care depends on whether someone with a similar situation happened to file a lawsuit in your specific county. Religious exemptions to healthcare mandates represent another major complication, with 3 nationwide injunctions currently excusing certain employers from providing insurance coverage for contraception or other services they oppose on religious grounds. If those injunctions become plaintiff-specific, millions of employees could suddenly find their insurance coverage changing based purely on whether their particular employer was a named party in the original litigation. Mental health parity enforcement, prescription drug pricing regulations, and telehealth licensing requirements are all similarly affected, with existing injunctions that might soon create a patchwork where identical medical situations receive different legal treatment depending on geography and litigation history rather than medical need or constitutional principle. So here's what you need to consider. If your ability to access healthcare depends on whether someone who looks like you filed a lawsuit in your federal district, are we still talking about equal protection under the law? Or have we created a system where constitutional rights are distributed like lottery tickets? That question becomes even more urgent when you look at what's happening with voting rights right now. Election litigation is about to become catastrophically complicated, and we're heading into a presidential election cycle. Currently, there are 13 nationwide injunctions affecting voter ID requirements, mail-in ballot procedures, early voting access, voter roll maintenance, and polling place locations across 23 different states. Under the Supreme Court's new framework, those injunctions might only protect voters in the specific counties where the original plaintiffs live, meaning the same state law could be enforced in 90% of a state while being blocked in the remaining 10% based purely on litigation history. This creates an operational impossibility for election administrators who need to know 6 months in advance what rules will govern their elections so they can train thousands of poll workers, print millions of ballots, and establish hundreds of voting locations. The National Association of Secretaries of State held an emergency conference call this afternoon, and according to participants, the overwhelming concern is that limited injunctions could create situations where neighboring counties operate under completely different election rules, leading to massive voter confusion, administrative chaos, and inevitable accusations of partisan manipulation regardless of what actually happens. What makes this even more volatile is that both political parties have weaponized nationwide injunctions to challenge election laws, meaning both sides are losing a tool they've relied on extensively. Between 2016 and 2024, Republican-aligned groups secured 11 nationwide injunctions blocking various election procedures they argued favored Democrats, while Democratic-aligned organizations obtained 14 such injunctions during the same period blocking procedures they claimed suppressed minority votes. With that weapon now effectively eliminated, we're likely to see election rules vary not just state by state, but potentially county by county within the same state, creating the most legally fragmented election landscape in modern American history. And that's before we even get to the business implications that corporate lawyers are quietly panicking about right now. Multi-state businesses are facing the prospect of navigating 50 different regulatory environments where federal rules might be enforced in some jurisdictions but not others based on the geographic limits of various injunctions. The U.S. Chamber of Commerce released preliminary estimates this afternoon suggesting that compliance costs for companies operating in multiple states could increase by $63 billion annually if they need to maintain different operational standards in different locations based on which federal regulations are being blocked by limited injunctions in which specific districts. Financial services companies are particularly exposed, with 4 major regulations governing cryptocurrency trading, consumer lending standards, and data security currently frozen by nationwide injunctions that might soon only apply in specific circuits. Banks are already gaming out scenarios where they might need to offer different products, charge different fees, and maintain different reserve requirements depending on which state the customer lives in and whether that state falls within the geographic scope of any limited injunctions. Technology platforms are facing similar chaos around content moderation requirements, data privacy rules, and antitrust enforcement, where injunctions currently providing nationwide operational clarity might soon fragment into a state-by-state patchwork. Healthcare providers and insurance companies are looking at potential nightmares around coverage mandates, prescription formularies, and telehealth licensing that could vary based on geography rather than medical standards. Employment lawyers are already advising corporate clients to prepare for different workplace safety regulations, wage requirements, and anti-discrimination standards depending on where each facility is located and whether that location falls within any limited injunction's geographic scope. What's particularly frustrating for businesses is the uncertainty factor, since they won't know which injunctions survive under the new standard until lower courts revisit each case individually, a process that could take months or years. But what almost nobody is discussing yet is how this affects the people who were supposed to benefit most from broad injunctive relief. And it's the argument that has constitutional scholars most divided. Civil rights organizations are expressing serious alarm that limiting injunctive relief could force victims of discrimination to fight identical battles in dozens of different courtrooms before achieving the protections that a single nationwide injunction previously provided. The NAACP Legal Defense Fund pointed out that during the civil rights era, broad injunctions were essential in implementing Brown v. Board of Education, allowing courts to prohibit segregation across entire states rather than just in the specific schools where plaintiffs enrolled their children. If those cases had been litigated under the framework the Supreme Court just established, desegregation might have required separate lawsuits for every single school district in every segregated state, potentially delaying integration by decades. Modern civil rights cases face identical challenges. When a state passes a law that allegedly discriminates against LGBTQ individuals, religious minorities, or people with disabilities, should relief be limited to the handful of plaintiffs brave enough to come forward and publicly identify themselves, or should it protect everyone in that vulnerable class throughout the jurisdiction? The Supreme Court's majority opinion doesn't really address this tension, focusing purely on Article 3 limitations regardless of sympathetic circumstances. Disability rights advocates are particularly concerned, noting that the Americans with Disabilities Act has been enforced largely through systemic injunctions requiring widespread changes to government services, public accommodations, and employment practices. It's unclear how effective enforcement would work under a regime where each disabled person needs to file their own lawsuit to access their own accommodations. Here's the fundamental tension. If preventing harm to vulnerable populations requires broad injunctive relief, but the Constitution limits courts to resolving specific disputes between specific parties, which principle should give way? And more importantly, who gets to make that decision? This Supreme Court ruling changes everything about how rights get protected in America, and we're only beginning to see the consequences unfold. The legal landscape has shifted overnight, creating uncertainty for millions of Americans who woke up this morning with protections they might not have by next week. Whether you see this as a necessary return to constitutional principles or a dangerous rollback of judicial safeguards, one thing is certain: the way federal courts protect individual rights will never be the same. If you want to stay informed on major legal developments that directly affect your life, make sure you're subscribed, hit the like button, and drop a comment with your thoughts on how this decision might impact you personally.